Again, I'd like to echo the same sentiments. Welcome. We are happy to be here today for our 2023 Risk Management Conference, Mitigating Today, Ensuring Tomorrow. We're going to start off by introducing our panel today. We have myself. I work as a senior risk control consultant within the risk control department. Janelle Howard, HAI Group Claims Manager. Janelle comes with a plethora of experience with our organization. And we also have Carrie Blackburn-Riley from Blackburn-Riley LLC as a legal counsel for some of the members that are in attendance today. So with that being said, I'd like to go ahead and get things started.
Good morning. I'm Carrie. Before we get started, I just wanted to give you a little background on premises security cases in general. I'm a lawyer in Maryland, so I can only give you legal advice about Maryland. But as a general rule, when you're bringing a premises security case, there's always a burden of proof. And there are certain elements that you have to present as a plaintiff to bring your case. Generally, you have to show that the landlord owner had a duty to the victim, that there was a breach of that duty, and that the breach of that duty was the cause of the injury. The duty, and this is where it varies state to state. In some states, you have a heightened duty. You have a duty to provide more security than you would in other states. For instance, in Maryland, we have a lower duty. It's not a low duty, it's just the ordinary negligence duty. We don't have any special or heightened duties. And so our duty in Maryland is, does the landlord know or have reason to know to expect this sort of situation? And with that, I will let Janelle take over.
Thanks, Carrie. Hi, everyone. I'm Janelle Howard. And today we're going to talk a lot about where is the plaintiff attorney's focus when bringing these premises negligent security claims. And the two concepts that you're often going to hear are foreseeability and atmosphere of violence. So foreseeability is, what should you have known? What risks should you have been aware of? And could you have foreseen that an event such as a shooting or a rape or any kind of violent crime would have happened? Atmosphere of violence is somewhat similar. It's when plaintiff attorney tries to establish that this is an environment where crime and violent crime is probably to occur. So the plaintiff attorney will be trying to establish that our insureds and our members should have foreseen, known that they had an atmosphere of violence on their property. The things that they like to often tout to the jury is the calls for service. And they will bring up that this area had lots of calls for service to the police. The police were often coming to the property. And you have to look for certain things in those calls for service and really pick them apart. And I think Carrie has a couple points on what you should be looking for when the plaintiff attorney presents these calls for service.
Thanks, Janelle. Calls for service are not always a fair gauge of what is actually the atmosphere on the property. Remember, calls for service are just that. They're calls, they're allegations, they're not proven established events. So when you look at the statistics as a whole, they might seem a little more intimidating than they actually are when you dig into whether they truly represent crime. The next thing you need to look at, or you need to have an expert look at for you, is what kind of calls for service are you getting? For instance, if you have a situation where you have a plaintiff that's alleging a rape, when you look at the calls for service and you see a lot of domestic violence, drunken disorderly, graffiti, breaking into cars, how would that have alerted you as a landlord owner to take different precautions? It probably wouldn't have. And your attorney's argument is going to be, it definitely wouldn't have. The other thing to take into consideration when you look at calls for service is, what is the geographic area about which the calls for service represent? As most of you know, the neighborhoods in your jurisdiction change block by block. And you may have a quiet block, and then you may have a younger, louder, more troubling block. And you certainly don't want the calls for service on a troubling block to be representative of what they might be in a senior community. So that's one of the focuses your attorney is going to delve into if you get yourself into this sort of situation.
And I think if we move on to the next slide, I would like to discuss a case that I handled that the plaintiff attorney had unfortunately had no trouble establishing foreseeability in atmosphere of violence. The case involved a 22-year-old male who was shot to death at the insured location. And what we found out during discovery was that this gentleman was shot in the breezeway. There was an opening in the gate that led to a unit in that breezeway where there was a bootlegger, and the bootlegger was selling candy and cigarettes, which is, nothing terrible, but he was also selling narcotics, and he was known to sell illegal weapons as well. Our insured was aware of this, and they allowed it to go on. The assistant property manager gave some particularly damaging testimony, and that she attempted to call the police. She was reprimanded by the property manager. The property manager told her to stay out of people's business and she would get herself killed. The property manager herself was allowing convicted felons to live on the property. She was giving preferential treatment to tenants that were friends of hers. And about 6 months after the shooting, she was arrested for public assistance fraud. Some of the problems we also had was our security expert looked at the property and he said that unfortunately we had no argument on foreseeability or atmosphere of violence. And that case ended up settling for $1.2 million. Now, I have just given you obviously the worst case scenario. So I'd like Carrie to give us a little bit of a better outcome.
So I'll give you an anecdote. It's not one of your case studies. It's just a brief setting. This is a hike property. It was not a public housing property in which the landlord was sued for a wrongful death. One of the residents was shot in the parking lot, and the landlord obviously had their statistics. They were trying to show there was a lot of crime in the area. We should have anticipated, and we were doing everything we could to combat it on that. Unfortunately, there was crime in the neighborhood. It wasn't violent crime. There were no murders, no shootings of that nature, but there was crime. But what we did to focus our case was prove that the tenant was a bad actor and that this was a targeted crime and this was intentional and it was going to happen regardless of what the property manager did. I looked into some very good evidence that allowed us to settle our case for $40,000 on the eve of trial. $40,000, as you know, is a very small amount for a person's life. But this particular resident, we discovered, had a snowball the size of an orange in his freezer, and that orange was cocaine. And he did have some priors on his record. So we were able to use that to mitigate our circumstances to a more positive outcome.
Definitely more positive than the one I had. I think we can move on to the next slide. So again, where is the plaintiff attorney's focus? The plaintiff attorney is going to look at what you did or didn't do. He or she will look at things such as failure to evict, failure to inspect. Did the inspectors search for defective maintenance conditions, but did they also observe other things that they should have reported? And also failure to transfer. On the next slide, I would like to another case that is currently ongoing, and this one highlights the failure to transfer. So in this case, as you can see on the slide, in May of 21, an 18-year-old tenant of ours was shot and paralyzed. At that time, the family requested emergency transfer, obviously for safety reasons. The insured received the request and approved it, but had placed the family on a wait list. In August, just 3 months later, the 16-year-old brother was shot at, but not wounded. And again, the family revisited their emergency transfer request, and they were told they were still on the wait list. Then in January of 22, the 18-year-old who had been previously shot was sitting outside his home in his wheelchair, and he was shot and killed. Later that month, a replacement unit was offered. Now, the issues that we're having with this case is the timeline. 7 months later, the family was offered the unit. But also what we've discovered and what plaintiff attorney is focusing on is that the member had a number of vacant units in the portfolio. and we are struggling to come up with a reason as to why the family wasn't actually transferred sooner.
I'll give you a counterpoint to that, or again, I got kind of lucky. In this case, the person put in a request to transfer many times, and for reasons that I never quite figured out, her transfer request was denied. Although many people along the way had highly recommended that the family be transferred, teenage daughter had been sexually molested multiple times. The son had been bullied. There'd been vandalism to the house. So the tenant had put in multiple requests to transfer for crime. And when it ultimately escalated up the ladder, it was denied. She was a week after it was denied, the mother was gunned down in front of her children and shot to death on her front steps. This is an atrocious case. Obviously, it would not appear well in front of a jury. It would be very sympathetic. We did get really lucky. In Maryland, there's a cap on damages, and we were able to settle it for just under the cap before we had engaged in a lot of discovery. And even better, the plaintiff's counsel had not done his homework, so he settled for. He didn't realize that the cap had recently been increased. So we settled this case for $375,000. But the argument that I made to get us there was a proximate cause argument, and it's something Janella just hinted about, was when you grant the request and you put them on the wait list, as many of you know, the wait list can be very long, especially when you're going for a multi-bedroom unit. Would it have even mattered if you had granted the request to transfer? In my case, what would have happened is that family would have gotten on the transfer list and would have been well behind several other people, and there were no units available. So we had a strong proximate cause argument. However, we also recognized that that proximate cause argument was not going to present well to a jury. It was the sort of thing that we could make in paper on a motion to dismiss or a motion for summary judgment. But we knew that it was never going to go well in front of a jury, and that's why we settled. And as I said, we settled very early before anyone could figure out where the problems were in our case on purpose. I also want to just mention that regarding failure to transfer, there are certain, you as a landlord only have limited powers. And in case of the transfer, and Janelle, if you want to pop back to that other screen before this for a quick second, this one, when you talk about failure to transfer, if there's no units for you to transfer, obviously you can't do anything. We're about to talk about failure to inspect and failure to evict. I do want to mention that you only have certain tools in your arsenal as a landlord. You can use your transfer policy. You can use your, you can put them on a transfer list. You can engage in mediation between neighbors that don't get along. You can even take breach of lease actions, but that doesn't always get you anywhere. With that, I think we go to my case study. So if you could jump ahead 2 screens for me, please. And I want to tell you about a particularly awful case that we had. This is actually a long time ago, so the settlement value is very small, but it was a particularly atrocious case that I represented. In this case, the child, a foster child, died, and it was due to physical abuse. The allegations were that she was deprived of nourishment, imprisonment, denied light, furniture, heat, and bathroom facilities by her foster parent. She was, I can't remember exactly, but I want to say she was about 11 years old. And when they found her, she was the body weight of the average 8-year-old. She had many lashings on her back. So this is a very horrible case. And in that case, the plaintiff's counsel brought suit against the Housing Authority, Department of Social Services, the Maryland Department of Human Resources, I believe, and a couple others, a caseworker. All of those parties had statutory limits on their liability. In this case, the plaintiff's counsel argued that the Housing Authority's inspector had failed to do a proper inspection, and we filed a motion to dismiss. The court found a factual issue on whether an employee with alleged notice even had duty to report the concern. On the eve of, we got it all the way to summary judgment. We filed a summary judgment motion, and then engaged in settlement discussions. In this case, factually, the real problem that happened, I'm sitting at the deposition of our inspector who's, doing the regular PMI inspection booklet. You're supposed to go room to room when you do your inspection. You check the stove burners, you check toilets, you check various things. Well, this inspector admitted that she felt like she was intruding when she went to the second floor of a tenant's unit. So instead of actually inspecting the second floor units, she would just simply ask the tenant, are there any concerns I should know about on the second floor, and take their word for it, then mark the inspection survey as pass or fail based upon what the tenant had said. So when the inspector admitted under oath that she did not inspect the second floor, that's when I knew we had a serious problem. Ultimately, as I said, we settled this case for $10,000, and I did it on the leverage of I argued in our summary judgment motion that the inspection occurred 6 months before the child's death, and there is no indication or facts to support that the negligent inspection would have identified the actual problem and could have prevented. Again, this was a proximate cause case for us, but the optics were terrible, and summary judgment is not always granted. We engaged in settlement discussions, and plaintiff's counsel at that point had mounting expenses and needed money basically to fund his case against the better defendants. He had a much stronger case against the other defendants, and we got fortunate and settled.
I think this is a good spot for JB to talk a little bit about what you should have as far as your written controls, your policies, and your guidelines.
Well, from a risk control perspective, to reduce that element of exposure and liability, I think that when you talk about, and just using this case in general, on an inspector that has rules, perhaps should have written policies in place in order to conduct an inspection. And then are they carrying out such rules and policies as directed? I think that when the agency and the inspection, just speaking to this one case, we should make sure that if we write it down, it's a written guideline or a rule, if you will, then we should be following that. And that is both in all aspects of managing housing. I think that if we don't have those things in place where we can take action as a housing entity to make sure that we are providing the right environment for both, tenants and those in the community, I think that the housing authority, it is a must to follow your rules. So if you have rules, you have written policies, you need to, again, check them, make sure that they're proper and appropriate. And then beyond that, making sure that you're following it. We often say if you have a rule that says that, after so many things, there's some kind of a consequence, even in the case of an eviction, that we want to make sure that we're moving forward. One of the things that I hear out in the field is we do everything that we're supposed to do when we get to court and we have a problem because we followed our rules and the courts don't take action. I think that we need to continue to do our jobs and not allow the outcomes of things that we don't have control over to impact our following our own written guidelines.
If I could tag on to that, Jibby, you talked about rules, you talked about policies, and then at the end you mentioned guidelines, and there's a very distinct difference between each of those things. Rules are rules. They're things you have to follow. I don't want to go so far as to say they're laws, but they're an established requirement that your agency has, or your company has created. A guideline is a little bit more gray, and it allows staff to have more flexibility in what they do. You can only establish so many rules. You can't create a rule for everything, and we certainly don't want a situation where you try to anticipate and create a rule for everything. So as you come up with these policies, these rules, think about whether it's a rule and a policy that you're going to say, black letter, this must happen every single time, or is it really a guideline? And think about how you can train your staff to understand when they need to use discretion and how to use discretion. And if the person in the deciding role should not make the decision, they need to know when to elevate it to the person above them. I always say that a favor will always bite you, as much as it makes sense in the moment to grant a favor and give somebody a little extension or allow them more time. That's exactly when my clients tend to get in the most trouble. So if you have a policy, a rule, a guideline, and you can apply it consistently, you can't run into a situation where somebody comes back later and says you showed favoritism to one over the other. So think about that as you draft these guidelines, rules, policies, what you intend and what you really are going to implement. Don't set standards for yourself that are unreasonable and that you can't, or you're going to have a different problem on your hand.
And Carrie, you made a very good point. You brought it up in your commentary there, the training. Oftentimes we kind of allow our operations to get in the way of making sure that we have some common sense training efforts, making sure that people understand our written rules or our guidelines and how to appropriately apply them. And the only way to make sure that that's evenly done in most every instance is to have those, periodic trainings for your personnel. And I know that it can, training takes people out of their day-to-day role, but it is important to make sure that you as the management or managing operator understand that those things that we train and we have conversations about, questions that may come up at the moment can be answered, and we can make sure that we're doing what we're supposed to be doing in an objective way and in a consistent and even way. So I think it's important not to forget that training piece and interacting with the members of your agency that will be carrying out your operational responsibilities.
On that training thing, and I digress, but this approach goes well beyond a security case. This goes to everything from training staff to address crime, to training staff to properly remove snow and treat for ice. It's very important that you refresh your staff regularly. You'd be surprised how many people just forget that they've ever been to a training, but they do snow removal every single winter. And when asked in a deposition, they go, "No, I didn't know we had a policy." And they just deny it because they just didn't know. So keep them trained and remind them on a regular basis.
I think those are excellent points too, because I've seen in a lot of claims where the plaintiff attorney will allege that there was a failure to train staff. And it doesn't matter if it's a negligent security case, if it's a slip and fall, if it's a sexual harassment. And when training is happening and we can prove to plaintiff counsel that it's happening.
I believe you froze there, Janelle.
That definitely helps our defenses as well. So I think on the next, still frozen?
You're good.
Good.
Okay. On the next slide, we'd like to focus on the physical security of the premises. Things that might seem simple to you are things that a plaintiff attorney is going to blow out of proportion. So common area doors, are they secure? The windows, do they lock? Are they checked every year? Do some of them have child safety locks? We've seen cases where tenants are routinely propping the doors open and are lease violations being issued to the tenants. Overgrown shrubbery and bushes, often we don't stop and think, can someone hide in those bushes? Can they hide in there and pop out and grab somebody and rob them? Your lighting, is your lighting adequate? If it's on timers, does it turn on at the right time? What is the intent of the outside or indoor lighting? Is it to provide a safe passageway? And then the gates and the fences, are they routinely broken? Are they fixed on time? I had a case recently out in California in which the tenants and sometimes non-tenants were continuously breaking the gate to the property. And this gate was similar to like a wrought iron fencing. You could fit your hand through it. The gate connected to fencing that was very similar, wrought iron, but the gate was constantly broken. And the insured finally said, well, we can't keep fixing this gate and have it continuously be broken, so we're just going to leave it open. And the local police were also aware that we were leaving the gate open. In this particular claim, 2 people were shot while they were sitting outside their unit, and their parents were there. So we had the 2 people who were shot, they were not dead, but they were shot. One was shot in the leg and one was shot in the arm. And the parents presented a zone of danger claim as well. We were able to prove that the bullet casings were found outside in the street. And our argument was that the bullet casings were outside in the street. The person obviously shot through the fence, and there really was nothing that could have been done. A gate would not have stopped these people. And the judge ruled against us that the open gate was a dangerous condition, and that we should have found a better way to secure the gate. In that case, the settlement wasn't an exorbitant amount, but it was still, a way to show how the plaintiff attorney will focus on one issue and is able to win a case based on that.
So in contrast to that, I had a case in Maryland where we had a multi-unit apartment building. It had a front door, it had a back door. Both front door and the back door had key locks. Tenants routinely would prop the doors open. The key locks would frequently get broken. In this case, someone came into the building. We don't know if they came in the front door or the back door or through a propped open window, but they came in. They happened to choose the first door on the right next to the front door. So plaintiffs argued it must have been through the broken front door. And they took their gun, they fired their way through the lock and the deadbolt on the person's private residence, then went into the person's house and shot the 2 people residing within several times. How the people survived, I will never know. The pictures were gruesome. But in that case, we got very lucky on summary judgment. It didn't get to a jury. The judge found that we had shown that the plaintiff had not proven the proximate causation of the injury. They hadn't shown how the assailant had actually gotten into the building. They didn't show that just because the front door was broken, that was how the person entered. They could have just as easily come through the back door or through a window. That went up on appeal, and we won on appeal. I think I just got lucky in that case, because sometimes judges do other things. The other thing I want to mention with respect to gates and fences is the appearance of the gate and fence. So obviously, if you have a gate and a fence, you want to keep it functioning and you want to keep it working. But really, what is the purpose of the gate and fence? Is it decoration? Is it actually to keep people out? Is it just to slow traffic? Is it just a gate that goes up and down to slow people into your community? Because if you just have like a gate arm and there's no fence to the left and right of it, it truly can't be there to keep out unwanted people. It's not there to keep out trespassers. So make sure the purpose of your gate and fence is understood by your staff, and you address repairs with the purpose in mind.
Carrie, you bring up a lot of great points, but I want to dig back at this slide and just talk a couple things, because in my role, I do go out and I see properties and make recommendations. And with the common area doors, I've had discussion with managers about making sure that they're secure. One of the things that I've heard in my travels is that, well, they just keep opening it, regardless of that. Sometimes it's important to have that conversation with those building members that have.
Jimmy, you just lost sound.
Purpose. Sorry?
I think you just lost sound.
Oh,
you're good.
Sorry. Not quite sure. Can you hear me?
Yes.
Yeah. All right. One of the things is to make sure that that you're having those conversations with those tenants in that building about the importance of that doorway. And I can't, emphasize that enough. The other thing that I find is when I walk properties is no one really, and I won't say no one, but a lot of cases we don't have that. We talk about overgrown shrubbery. We don't have a plan in place to manage our vegetation and landscape. And I think that's important to think about as you look to improve perhaps review your current property status as it relates to security, making sure that the tree canopies or the tops of the trees are not hiding that valuable lighting that needs to make it all the way to the ground to illuminate the walking pathways for your residents and or visitors. So it's just important to make sure that you're reviewing your physical grounds routinely to make sure that that lighting is adequate and that those bulbs are not out when you're out there just taking a look at your property. So it's important to have some kind of a thought process as you manage that. And that speaks to, crime prevention through environmental design. Again, as properties are going through these RAD conversions, again, having that input, having that discussion. One of the things that SEPTED has taught us is they've introduced a standard referred to as the 2 foot, 6 foot rule. And that is that shrubberies, greenery, vegetation should not exceed or come above the ground level more than 2 feet. And people say, well, that's kind of not practical for older establishments or older residents or communities. Sometimes you have to, you're going to have to just chip away at it and keep moving. But as it refers to the 6 foot part of that, we talk about tree canopies. They should not come below 6 foot. So a 6 foot person should be able to walk right up under a tree canopy without it ever interfering with their head or their eyes. I've seen cases where that becomes a problem. But again, the reason that rule or standard is there is to give those that are using your properties the opportunity to be able to identify hazards and dangers ahead of being impacted. So again, speaking about the shrubbery, I believe as Janelle brought up, is if you have shrubbery that's, 3, 4, 5 feet, that allows for people to hide and provide for that ambush point that could be impactful and, end up creating some type of litigation or claim with your organization. As it relates to the fencing, I just recently had something similar, Carrie, where I was out doing an inspection, had a wrought iron style gate that had an access point affixed to it with a mag lock, and it was just not, it was broken. Of course, I did make the recommendation to fix that, but it was broken. So we wanted to make sure that, when these things get in disrepair, if you've had them repaired a number of times, and I suggested this to the member, is that maybe it's time to find you a different vendor to provide you the repairs that you are desperately in need of, because sometimes different vendors think about security related issues in a different way. So it's just, again, don't keep doing the same things the same way and expect a different result. It's time to come in with something new.
So I want to just jump back onto 2 things you said. With the gates and fences, they do get broken all the time and they get very expensive to fix. And I'm just thinking this out as we're talking. At some point, and I think Janelle has a case about this that she might be able to mention, fixing those fences, they just get too expensive and the landlord says, forget it, we just can't do it anymore. But if that's the approach you're going to take as a landlord, you need to come up with a way to let everybody know in advance that this gate or fence was never a security intent anyway. It was there for design, for aesthetics. It was there to slow people down because kids ride bikes in the neighborhood or whatever. Maybe you want to do a community meeting in advance just to let everybody know. It may seem purposeless for you to have a meeting that says, hey, the fence keeps getting broken and we want to talk to you about it. But if you do that meeting well and use it as a way to build to your next step of taking down the fence, you can say to everybody in advance, this fence's purpose is really just decorative. We're frustrated. How do you feel about us taking it down? And maybe get your community on board before you take it down. Before we get too far, I want to mention the windows and the common area doors. JB said to talk to residents about, their role in that, whether they're propping open the doors, whether they're breaking the locks, whether they're losing their keys so often, and other neighbors or not neighbors, other persons are getting in the building, they're giving their keys away to friends that they want to come visit them in the middle of the night. You as a landlord, this is where your tools come in. You obviously, you're not going to terminate someone's lease for this. It's not going to stand up particularly well in court, but you certainly can build a case saying, you know, we sent you notice that we've learned that you are routinely propping open the door. Please note that this is a violation of your lease and we want you to stop. So warn them that these things are lease violations, so you can at least show that you as a landlord are trying to take acts. You certainly don't have somebody who can go out at all hours of the day to unprop the door. So the best thing you can do is show that you made an effort to educate and advise neighbors that their habit of propping open the door or losing their keys is jeopardizing their neighbors.
And I'll add on to that, you know, just as a plug for the next session or session 2, they do have a make it clear and how to communicate with your resident, write resident communications. And that's important to write those communications that will deliver you results. So I encourage everyone to make sure that they attend session 2 after our session, and that one runs from 11:05 to 12 noon.
So Carrie and JB, I'm just wondering, in the case that I had brought up in our broken gate case where our insured just decided to leave the gate up and open because it kept getting broken, the police were aware. The police agreed with us that we should just keep the gate open. Now, if our insured had gone and just torn down the gate, just took it away, now the gate's not even there. What kind of trouble are we going to be in then when plaintiff turns around and says, well, you had this gate, you couldn't keep it repaired, so you just took it down? How does that improve your security?
So this is where I say the optics of presenting it to the community and telling them why the gate and fence is there in the first place. I mean, if it's a little 3-foot wall, it's clearly not going to keep people out. So you need to let people know in advance, this is not security. This is just a deterrent. It's to slow people down, or it's literally just to mark the border of our property and show you where our responsibility ends and the city maintenance for the street begins. It's just aesthetics. So by presenting that out to your public, to your population in advance, it lowers their expectations that they have security from a fence. And I think if you, especially if you document your efforts with community meetings or notices or letters to tenants, you can then present that. In your case, the judge, I'm a little stubborn, so I would have pushed you to push more on and go to trial on the proximate causation of shooting through a fence. Isn't going to stop anyone anyway. But in your case, the judge, for reasons of his own making, decided it didn't matter that the bullets came from the other side. But if you could have presented evidence to that judge in advance that said the fence was never designed for that intent, and shown that you had made that clear to the audience in advance of defending the case, I think it would have been more helpful for you.
And I probably would say that also in that case, that is expectation is real big. Fencing in most cases, when you look at general chain link or ornamental style wrought iron, light iron or metal fencing, it's meant to be established that territorial outlook on your property, as you say, establishing your boundary. But when it is touted as a, when you add code locks or fob locks or push locks or key locks to these fencings, that says more that it's not for territorial understanding, that it's more for a barrier / preventative protective type of value. And again, to Carrie's point, that has to be laid out with the residents that will have some type of expectation behind it. So if you've been locking a fence, the question that I would have from any standpoint is, okay, you've been locking this fence, all of a sudden it becomes broken, it's in disrepair, and you are thinking about removing it. The question that I would have is, why did you have it there in the first place? Why did you put locks on it? And was that the original intent was to provide the people on the other side of the gate, the residents, that type of protective value. So if you're providing protection to them and you tear it down, absolutely, there's probably an argument in court. Why did we think that the neighborhood was or the community was in a way that we needed to protect it, and then all of a sudden we wake up one day and it's no longer a concern? So we just have to be very careful about that one.
So I think we can move on to the next slide. We have a couple more here on what the plaintiff attorney will focus on. Security cameras, are they working? This is a big one for me. I have had claims where our members have security cameras that have not worked in years. And their logic is, well, keep them up so people think that we're surveilling. But the problem is that the security cameras are also giving people a sense that they're being protected because the security cameras are up. And the plaintiff attorney will say, well, you have them up and they're not working. What good are they doing? So my personal opinion, and Carrie and JB may tell you different, but if you have security cameras up that have not worked in years, please take them down, because they're giving people a false sense of security to rely on. If your doors have a door monitor, does this person have any authority? Is it just a tenant who does volunteer work and writes down the names of people who are coming in and out to visit others? But is that giving the perception that this person is offering some type of security? And then the gated doors. The gated doors, are they creating the illusion that the property is secured? And is that really the intent? And I can see Carrie is just getting to comment on some of these things. I see you over there.
I do get anxious. On the security cameras, so I agree with you wholeheartedly. If your security cameras don't work, stop giving people a false sense of security. But I also, even if your security cameras do work, you need to let people know why they're there. They are there. Are they live surveillance? Do you have somebody in a booth somewhere watching them who's like quickly going to get again on the phone to the police and say, hey, we have a suspicious person in elevator number 2? You probably don't have that. What you probably have is a recorded system. So you need to let people know that these are not live monitored cameras. So nobody is going to come to their rescue and call the police, and stop giving them that false sense. So post that signage. I'm sure you've seen it in your local mall. That's there for a reason. The other thing about your security cameras, also remember that when you do have a problem on your property, a lot of these security cameras write over themselves after a period of time. So you need to make sure that you save the tape and save the tape from all the different angles. So check in to make sure your system works. Recording is only as good as how well the equipment works. I had a case several years ago, a totally different case, in which I was doing due process proceedings, and the agency would record their proceedings, but nobody bothered to check to see if the recordings actually recorded. And we were responsible for coming up with an appeal transcript, only to discover that the tape recorder didn't work and we didn't have one. So check your equipment from time to time. That is a problem. It seems obvious and goes without saying, but those are the important things. There's also, everybody talks about, you can't record without my knowledge and permission. So if you're posting signs that say we have cameras up, if the cameras are posted in obvious places, people know they're being recorded. Your cameras probably don't record audio, so you don't need to worry about that. But you should think about making sure people know that they are being recorded, and it doesn't have to be consensual if it's open and obvious. The other thing I'd also want you to keep in that the security cameras you have only show like a limited angle. They get this, they don't get this. So you need to make sure that your cameras are focused on the areas you need them to be focused.
One of the things that I want to, thank you, Carrie. One of the things that I wanted to bring up, and it was pointed out by an attendee, is the word security cameras. One of the things when you really look at it is the camera security. And I think that even in our language, because it is common language to say security cameras, but really we want to make sure that we are, engaging our public, our tenants, our visitors, our residents, and all those people that are going to pass through these areas, and make sure that they understand it's surveillance. Because to Carrie's point, it is not a, it's not what we call two different things, passive and active when you talk about video surveillance. Passive being that it's just something that we'll come back to for evidentiary purposes, to help us see something that maybe we thought we missed, or to confirm something that we know. But when it becomes active, there is that expectation that someone's on the other end knowing exactly what's going on in the vision or the view of that camera. So it's important to make sure that we do provide information as we post on our property, just to make sure our language is speaking to surveillance and not so much to security, because that implies, again, that there's people are being secured. And I think that we just have some of the signage that's out there still says that. I think that again, for most of the places that I've gone to, I encourage people to stop buying the generic signage because it's across the board. I think that you really need to be particular about the language that you use in any of your signage in that regard. As it relates to just speaking on the doors, the door monitors, again, when you have security personnel, whether contracted or in-house, acting as a monitor for the door, make sure that there are either post orders or some type of guideline so that they know how to properly vet people that will be entering a premise. I've too often, even just as a person going out inspecting properties, have been able just to come in and say, hey, I'm here to look around, and I get no other further challenges, which to me sets up for some type of breach in security for the residents and the people that are looking for this to be a barrier and a way to filter who is allowed to enter the premise. So it's just very important to make sure that if you have someone there, that they understand what their role is. And if they don't have the authority to turn people away or contact the police, if those guidelines and those things are not put in play, I think that you're really doing both your residents and your organization a disservice on that note.
Real quickly, before you get to your case, Janelle, I know we're now looking at time. There are a lot of great chats coming up. I don't know if people were watching them, but there's some good comments. You should scroll through those as well.
So finally, which leads me into my next slide, is do your financial records indicate deliberate decisions to forego security investments? So the last case study I want to talk about was a case called a home invasion and robbery. Unknown armed assailants accosted the plaintiffs as they were walking between their apartment and the mailbox. We looked into the property. The property did not have an overwhelming atmosphere of violence. It had your typical crime. Our security expert gave us a good review of our property, said that we had all the proper security measures. So based on that, we had filed motion for summary judgment, and we were trying to get the case dismissed. But during discovery, obviously, the plaintiff counsel had asked for financial records. They asked to see what we were spending on security and, this type of evidence. And the judge, and I want to read, and I'm sorry for reading, but I'll read to you the exact words from her ruling. She ruled against us, and she said, despite the persistent violent crime at the complex, its location in a high crime area, the warnings of 2 security personnel regarding the need for increased security, just 2 months before this armed robbery, the defendants, our insured, chose to drastically reduce security, opting for a more, quote, budget-friendly package. That case, in which the plaintiffs had minor injuries but had alleged that they had severe post-traumatic stress, that case actually settled for $1.6 million. So again, just just be careful of what your financials could show when it comes to discovery.
Oh, okay. Janelle, just that goes to show you exactly that while you may not have a heightened duty to provide a secure environment, if you start to take on increased measures, you do have a heightened duty to perform those measures accurately and effectively. So don't have a broken system in place. I was just reminded that everybody cannot see the chat. So somebody had noted that the video footage works very well for using to support your breach of lease actions. I thought that was a great point. Somebody else also noted that they have so many cameras on their property, even if they had live surveillance, there's no way that they could look at all places at any one time. JB, I think you've been monitoring it a little more carefully, so I'll let you jump in on what else you've seen.
No, one of the things that, we've discussed with risk control, and this is just a PSA, we're looking to increase the availability or opportunity for perhaps opening up some CPTED training for members. We're still kind of working out the details, so I would just say there's more to come on that. But it's definitely the things that we're coming across in the chat. Again, talking about the cameras and some of the other issues with that passive and active monitoring. So it's just important to make sure that we're looking at that perspective.
I just saw.
I have a question for Carrie and Jay. Using surveillance footage for lease violations and eviction cases. I have a case in which a plaintiff is alleging that we are violating her privacy rights, and that the concern is that our insured is using the camera just to evict people, and we're having to defend that matter. So, is there any issues with using surveillance footage for lease violations and evictions?
I would ask you, where are the cameras located? No, you absolutely can't have it in the tenant's unit. And I would strongly.
No, they're in common areas.
I think it's perfectly okay to have it in common areas, especially when you disclose it. The cameras aren't hidden in any sort of way. I mean, people should know you shouldn't just, flaunt your cigarette as you walk through the lobby when it's a no smoking building, and there may be repercussions. A camera is no different than a live witness. It just happens to be a more reliable witness when your live witness is no longer available.
Right.
So I don't think there's a distinction in that regard. There was a comment, and I saw it very briefly, and I apologize, about what happens when there's a superseding cause. And I think the question was something, and I'm just going to create my own fact pattern, was something like, if the person starts the action that then leads to the violent crime. I have a case right now that we're literally on notice. It's not in litigation, and I'm very curious to see how it will play out. We have a tenant who had some sort of relationship with another tenant's daughter. They broke up. They were getting in a fight in the elevator, I believe. The tenant's adult daughter, we're not talking about children here. The tenant's daughter called her brother to the scene. Her brother got into it with the tenant. The tenant then got into some kind of verbal altercation, I believe, with the tenant's adult brother, or with the neighbor's adult brother. Then they went out in the parking lot, and our tenant stabbed and killed the adult brother. So we had a superseding cause. We clearly have the brother confronting the tenant / assailant, but I'm not really sure how that's going to play out. I mean, what could the housing authority have done? This would be an intentional act. This is a targeted act. This is very different than us knowing that we need to put up better lighting to prevent against crime. This is a situation that was going to happen regardless of what we did. And when we get to trial, our expert in that case may not be a security expert statistician. It may be a criminologist who's going to say, there's some crimes you just can't prevent against, and you need to understand that there's nothing you can do when it's targeted or intentional, and explain that to a jury.
But I think, you know, that I want to go back to the first case I discussed in which we had the gentleman who was shot in the breezeway by the bootlegger. I mean, we had evidence upon evidence that that was a result of gang activity. So I want to go back to foreseeability and atmosphere of violence. So, you know, if you have a property where, you know, the gang activity is known to happen and you should be aware of it, you still could be held liable, even if it is clearly an intended directed act.
Okay.
Yes, but you also have to keep in mind what you as a landlord could really do. Like,
Right.
I have another situation that arose here in Maryland recently, where there was an unauthorized, unplanned event that the housing authority had known about in past years, but didn't know about this year. It was an unscheduled event, and they took no actions to prevent something they didn't know about. It turned out, you know, you had a lot of different gang members who caused shotguns, people were harmed. In that situation, what is the housing authority's role? And you have to remember, we're not police. All we are is landlords, and we can't terminate, we can't trespass and lock them up and have an immediate reaction. We can certainly say, hey, please stop. And if you don't stop, we're going to go to the court. And in 6 months, the court's going to issue a ruling, but that ruling is not going to prevent what happened today. So we need to make sure that our role as housers is very clear. We are not policers, we're housers.
All right. I want to thank both of you for joining today. I know we're coming upon that hour. It was, all of your points were outstanding. And to our attendees, I want to say that my understanding is that we are going to, session is recorded and will be provided later, and any things that we found in the chat that we didn't get an opportunity to answer, that we will come back and probably put something out in the very near future to address those things that we did not cover during this session. So I just wanted to wrap up and say thank you to all of our attendees, the presenters and on this panel, and HAI for graciously putting this opportunity on for all of our members.
Thank you.
With that being said, I think we have approached that 11 o'clock hour with respect to everyone else that has to present today. You guys got any last quick comments? Like 30 seconds?
No pressure. I did bring to some of your attention in advance, there's a PIH notice 2023-10 issued in April of 2023. It's all about some grant funding that's available for safety measures. And I noticed when you dig into it, if you are fortunate enough to be awarded the grant, and they recognize that there's not enough money for everyone. If you are awarded the grant, you are not allowed to use the grant monies for automated surveillance and facial recognition technology. So keep that in mind if you get your money that way, that current technology may be too advanced for you and you're not allowed to use it.
All right. Well, thank you both. And we look forward to seeing everyone else in the next session.
Take care. Thank you.